Oh, really?
Yeah, it's for marketing.
It's bizarre.
The more they dry out. Yep. And then we bring
Okay, so we'll start with the Meyer case. As I mentioned before, the state side is to my right, the children's attorneys are in front of me, and to my left, family attorneys. But because this case was the teacher versus state, what I'd like is someone from the state side to volunteer to do a little argument before the rest of us can act as the Supreme Court justices, ask questions and whatnot. And then someone from the family side, and that was up to Brooke, right? To you, and then you four children's attorneys. But someone from the left side of the room to volunteer to be counsel for the teacher appellant and do your argument with us asking questions. And after we do that, we're going to, as a group, deliberate as if we were the justices that heard that case, with obviously different points of view as to how the case should be resolved. Okay, any questions? All right, so I need a volunteer from here. Steve, all right.
Get it over with, just don't bother, go first.
I know, it's like you don't know exactly.
And then someone who is representing the teacher, Maya, who's actually the appellant, and will go first.
I'll go over here.
Kristen, all right, okay. So because you're the appellant and you're going first, you want to, before you sort of launch in your argument, tell the court what this case is about, how it is that, you've got, you have procedurally come before the court.
Okay.
Okay.
Would you like
So
me to
it's-
stand?
Yeah. No, you don't have
Okay,
to say,
great.
as long as everybody can hear you and I think
Okay.
we're fine.
I'm the teacher.
And by the way, if you want, I think it's fine to just interrupt, as long as we sort of, go one at a time interrupting her. So you don't have to wait for me to acknowledge you. You can just say, counsel, and then ask whatever question you want to ask her. Okay, but you can't because you're, right?
I can what?
You can't ask her any questions.
No.
Because you're the attorney, everybody else is a judge. All right, okay, go ahead.
Okay, teacher has been violated Act 1922 in violation of not teaching English only at this Zion school, and was teaching, I want to say Bible studies in the German language. And we are here to say that is a restriction on the parents and teachers' right to, because their native language is restricted, and they have the right to teach these studies non-academically in German.
Counsel, does the statute state specifically that it's against the law to teach a language other than English in general?
It doesn't necessarily say that it does in general in academic studies. It seems to state so, but because it was alternative to the studies, it didn't seem to harm the state or the child to teach part of the religious curriculum in German.
So it had nothing to do with a specific age or a specific grade that you
Right.
need to have attained?
Yes, the child, these for children, for English only for 8th grade and up and under, and I don't remember. So it did prohibit teaching anything other than in English only for children under 8th grade.
Counsel, why do you feel that if this was their native language, that it should be introduced into the school if other children were speaking English and they were teaching it at the home?
Why do I think they should be able to?
In the school?
Because we feel that there is no harm for children under 8th grade to have other languages, and we think it is restrictive to foreigners to speak in their native language. Therefore, it was a restriction on the liberty of the parent to choose a school that has studies that have some other language other than the per se languages that are excused, which would then Latin, Greek, and other languages. The state's purpose for this act is to create children who are connected to the United States and not be influenced by their parents' native land. And we don't think that, again...
So doesn't that make the statute legitimate and rational, the state's purpose of we want children to become, citizens of the U.S.?
Yes.
So I guess, go ahead.
They didn't, well, here on appeal, we're asking is that it is restrictive in that the state doesn't have any rational basis to entirely on just having English only at this particular
So you keep
school.
saying it's restrictive. How is the statute, I'm assuming you're arguing the statute is unconstitutional as applied to your client or in
Yes.
general. How is it unconstitutional?
It's restrictive because there are many people who've come to the United States that speak other languages, and it's important to allow parents to continue to speak that language and for schools not to deny English and children who don't speak English at home to receive foreign studies per se. So it's denying English only
So
speakers.
your client was convicted criminally, correct? For violating this statute?
Yes.
What rights are at stake, or what argument do you have in terms of your client, the teacher's rights?
My client should be able to educate the children that will allow to be able to use other foreign languages.
Where does that right come from?
Liberty is a fundamental right that parents can choose to send their kids to
But you represent
school.
the teacher,
Oh, yes,
not...
that's right. I am not sure right now. I've lost my train of
Does
thought.
co-counsel want... You can...
Just a side note, Your Honor, on the context of this legislation, it was passed as, we feel, as a knee-jerk reaction following World War I, where there was a
Can you help
adverse
her to
reaction to
answer
all
the
things
question of what is the nature of your client's right?
It's a
That's at
due
stake?
process violation, Your Honor.
Okay. So what particular, can you be more specific about that? Your client is a teacher who's teaching in grade school. How does your client have a due process right?
It's-
14th Amendment allows him, I think it's a due process under the 14th Amendment guaranteeing that all people, including the teacher, to use other languages.
So the state has some power in terms of intervening in children's education, correct?
Yes,
You would-
in curriculum, per se, to anything that's to do with civic duties and
So what do you have to show in order for this court to be convinced that this statute is unconstitutional?
What I'm saying is it's prohibiting all foreign language in schools. And
What's the test or the standard that you want this court to follow?
I want the standard is rational basis.
Okay, because before you said that your client had a fundamental right. Does your
Yeah,
client?
because I was thinking I was in the family. So as the teacher, this case should be, I asked the court to use rational basis that the teacher did not violate the act because of the due process in the 14th Amendment, that all
I saw your co-counsel also, your co-counsel, right, Brooke?
Yes.
Is there something you want
I was
to
just
add?
going to mention that also in the Act, they said that the ancient or dead languages are not within the spirit or purpose of the Act. So they're saying that Latin, Greek, and Hebrew are okay to be taught, but not German, French, Spanish, and Italian. So
But isn't the reason for that, again, to promote civic development in terms of these individuals, children who are coming in from other countries to learn to be citizens of the United States and therefore to study, in the English language?
definitely, but just as mass may be said in Latin and may lose translation into English, it could be said for any other language as well.
Did you want to add anything about the standard of review that I was asking about?
No, I didn't have anything for that yet.
Okay. Let me hear from the state. Steve?
So the state of Nebraska maintains that this is not a violation of the 14th Amendment or due process, and it has a rational basis in maintaining.
But doesn't the teacher, and the teacher mentioned the family as well, have some due process right?
It's certainly that the family and the parents of the children have a due process right. However, under the rational basis standard, the state also has a right to maintain that there's a standard of assimilation of the children within the school system as well as society in general. There's been a great migration, especially within the state of Nebraska in the past few decades, of a lot of different speaking cultures. And it's the duty of the state to educate these children in a manner in which they'll become contributing members of society. If we allow education in different languages, obviously you can see the differences between that assimilation. The state maintains that it does have a right to compel attendance at schools, and with that attendance at schools, the state also has the right to mandate the language in which they're being taught. This includes a requirement that the children be taught in English. The state maintains it's not a violation.
Isn't mandating the language going a bit too far?
Mandating the language has a specific rational basis within our society. If all members of society are not speaking the same language, or at least aren't familiar with the same language, how can they accomplish any contribution to that society in itself?
We're talking about a 10-year-old that, maybe just recently came to this country.
But as a
and doesn't know.
10-year-old,
Go ahead.
the state would argue that these are the formative years of a child's development. It's much easier, as science has shown, that a child learns a language much easier at the formative years than an adult at an advanced age. The state maintains that we have enough information to show that it is proper to train the child at these young ages, which is why the state law only goes to the 8th grade. If a child wishes to learn a different language, or if a parent decides to teach a child a different language after 8th grade, they're more than happy to do that. It's within their power to do that. However, the state still maintains that in order to give these children the opportunity to progress within society and to assimilate within society, they have a rational basis for maintaining the child be taught in English during those formative years.
Anybody have questions of the state's
Counsel,
attorney?
Are you insinuating that a child of, yeah, but,
Wrong side.
I doesn't mean I can't ask you a question?
Okay.
I can't ask you a question?
Yes, you're a justice.
I can't ask you a question. I have to make an informed decision. Oh, no, I was asking her questions. I can't be counsel. No, am I not supposed to ask her questions?
Yes, you are. You are.
Are you, well, that doesn't take much. Are you insinuating that a child of 10 years old could be regarded as somewhat harmful to society if he were to be educated bilingually as opposed to maybe a 12-year-old?
On the contrary, the state maintains that the child would not be harmful to society, but harmful to the child itself. Without the proper education within society, that child would not be gifted with the opportunities that America offers. So certainly the lack of education and learning the English language would harm to the child and not to society. But having said that, without that contribution of a child, society as a whole would be harmed by not having anyone contribute to it.
So you feel that's the real consequence?
The consequences, loss of the child as well as loss to society.
Thank you.
Does the appellant want to?
Yes, we understand that the state does have the power for mandatory to compel attendance and make reasonable regulations within the schools, including the requirement to have instructions in English. But we also, what we're saying is that your argument that children will not become integrated into the society because some foreign language is being used in the schools is not compelling enough to abolish all foreign language in schools. Therefore, we're asking the court to allow, to consider this statute unconstitutional because it's abolishing all foreign languages, which is for both English-speaking and non-English native tongue speakers across the board.
All right, counsel. Court will take, oh, one last thing and then we'll deliberate.
The child was having trouble speaking English anyways. Wouldn't it be prudent to speak some
You have to
German?
address the court, no.
Oh, sorry. It would be prudent to, obviously, to have teach the child bilingual skills anyhow, so you're going to have to converse in two languages regardless.
Okay, thank you. Okay, so let's deliberate.
I have one more question.
All right. We're never going to get through all the cases.
All right. Counsel, am I misunderstanding that do you want the court to look at this issue under rational basis or strict scrutiny? Because you just made the argument that the state isn't making a compelling enough point, which would mean strict scrutiny.
True.
What would you prefer?
Because there are parental issues of liberty, that's where I'm speaking, but on the act itself, it's a rational basis that the state finds it's not, I can't think of the word, Professor Ryan, come back. But yes, rational basis for due process 14th Amendment.
Okay, one more
This
comment
case.
from Paul.
Oh, it's a procedural question. Advocates for the child, when do we speak? Are we like dead leaders?
Well, see, that's the problem, okay? And that was one of the questions and the issues that I touched on last class. It's a while in the history of the U.S., even though the first juvenile court started in 1899, there were no children's lawyers. And in fact, in these few cases, we don't even have the family coming up. It's the teacher that's been prosecuted. So we'll talk about how these become family and children's rights cases.
Okay.
But good question. So you can be engaged by being one of the justices in the deliberations now.
Okay.
All right? So let me hear from some of you that have been quiet. How should we decide this case and
Well, I
why?
already interrupted, so I'll just say,
Go ahead.
don't you
can
think
start.
there's a possible free speech violation here? Is that possible? That we
That
could be
is
under
possible,
strict
I would
scrutiny?
say.
It's based on the content. It's German. It's discriminating against foreign languages.
That's true, but this case in hand is the act itself
So wait,
yeah, it's-
right, we're examining the statute and whether the language of the statute violates the substantive, and that's one of the questions that I'll ask you to think about. The teacher has mentioned due process, and what's the difference between substantive due process and procedural due process?
Yes.
Yes,
The overlaps. The overlaps.
What is the
cases.
difference? So we're looking at the language of the statute that, again, doesn't allow this teacher Meyer to teach German to the pupils below the 8th grade. And he's asserting that that statute violates his liberty rights under the 14th Amendment. So liberty meaning due process, right? Life, liberty, or property. But is it substantive due process or procedural due process that's at stake is one question. And then the other question is what standard of review should we use? I heard from both parties that it should be rational basis, but I'm still, I want to be clear why. So, let's talk about those two questions right now. What due process argument do you think that counsel had raised?
Just so, oh, sorry. go ahead.
Yeah, go ahead, Carrie.
Just so I understand, I guess I'm a little confused. We're talking about the due process rights of the teacher?
Yes. So what due process rights, is it substantive or is it procedural, and what's the difference?
Well, I guess someone else could take the wheel right now.
Substantive. I would say substantive.
Well,
No?
I would guess that it's substantive.
Kristen's saying, you're all saying substantive,
Yeah.
It's
but
a specific portion of the curriculum that it's content-based, that he's not allowed to teach based on the content of what he wants to teach.
right, and we're looking at a statute on its face
Yeah.
that violates, it's hard to me to talk about it without using the word, when they say, don't define without using the word, well, it's something, a difference is, later on when we read Galt, for example, we're talking about procedural due process. And the two questions that you ask yourself in procedural due process is, number one, is process due? Does this person have a life, liberty, or property right? And then what process is due? So you're talking about a particular process. Whereas here, we're looking again at the language of this statute to determine if the statute violates this person's rights.
When they look at the means end test, and did it have ascertainable purpose, is that what you're getting at?
Sure, go ahead.
Okay, so in order to do that, they would have to look at the statute and say, does the statute have a means end test? What's the
Right.
purpose of the statute?
Okay, but before we get to that, we have to examine, let's say the teacher's, her right as a teacher versus, for example, an easy example is somebody that has a different kind of liberty right, someone who is in danger of being imprisoned, right? You would all agree that that would be a fundamental right, because Melissa asked earlier, is that a strict scrutiny test to which the state would have to show, it'd be much more difficult for the state. But I heard everybody, talking about that the state here has to show a rational basis. So I think we can agree that that is the test. So if that's the test, it seems fairly easy and straightforward in terms of what Steve had argued before the court, that the court had this, legitimate interest promoting civic development, assimilation, etc. So why should the statute fail?
Yeah, going on that, I think that I'm having a hard time with it because of the recognizing, the liberty interest at, the teacher having these, I guess, I could see it on the parent side, obviously, they have a fundamental right, but where does it, you could read the holding and reasoning, but I don't know if I necessarily agree with it, as to why the teacher has it. Does that make sense? I think I'm just struggling with that.
Hold that thought. All right. Any other
I think
statements anyone wants to make as one of the justices deliberating, and reasons for holding one way or another?
Well, they mentioned that the obvious purpose of this statute was that the English language should be and become the mother tongue of all children reared in the state. But they didn't think that it warranted the doing away with all foreign language in the schools. It was just over the top. It was just way too restrictive, because it's a benefit for all students to learn foreign languages in the school. They also thought that kids under 8th grade really don't get the other language. So they had mentioned that it's really not, it's not going to do any harm. They have no rational basis to say no to all foreign language. Were they supposed to prove? Or was I supposed to prove the rational? I'm trying to think that now. Do you remember?
That's the standard by which this
So
court
is it my
looks at the statute.
duty
The state
to
has the
prove
burden
that?
with strict.
So they haven't proven that they have a rational basis to abolish all foreign
Okay.
language. Because it's really not just about German, it's just
That's right.
about having other languages in the children to experience that.
Now, getting back to Kerry's legitimate question, it's Meyer v. Nebraska. Why are we reading this, and why do juvenile rights and family law experts still cite this, 1923, cite this case, and you'll see Prince and Yoder as well, Pierce, today, to argue about family rights, when the family, the parents, children, you mentioned, Paul, were not parties. Why is this, how is this a family right case? Melissa?
I took a stab at it. I feel that it's applicable because instead of saying, no, you can't teach these things at a public school, the parent has the power to say, if I don't agree with what's being taught, I can take my kid to another school, and I, as the parent, have a right to decide where my child's going to go to school. Maybe based on the curriculum, maybe not, but it shouldn't be up to the state to step in and use police power to say what my child is going to learn and what they aren't.
Well, they kind of do though.
They do, but that's, I think, to an extent, it's constitutional, and then obviously with this case in particular, they're stepping over the line.
So looking at it from a family point of view, I think the argument you're trying to make is the fact that even though this was the teacher in the state, it was still denying the liberties of the child to learn the foreign language under the guise of the state trying to protect society, or the state having a rational basis. So even though the child was not a party to this decision either way would have an effect on the child's liberty too. Is that what you're basically looking at as the family?
The family.
Right.
Because again, in the early case, the children per se really had no voice. It was all about, if you would be, even if you were talking about, children's rights, the right of the child to learn this language, it really was the right of the parent to have their child instructed in one way without the state interfering. And the state making an argument that, the government has not only the right but the duty to protect its citizens, and young children are its citizens as well, and therefore the state also has a right to interfere. So children's rights were really more about family versus state. There wasn't that third piece of the triangle yet in these early cases. But in any event, Maya v. Nebraska is Maya the teacher, who goes all the way to the Supreme Court, appealing the criminal conviction, but the Supreme Court, while, narrowly deciding that controversy, makes it a family law, rights case. Talks about the family's substantive due process right to make decisions regarding children, and that the state can only interfere if there's a rational basis, and that there was no rational basis for this statute. And that's basically it. And that's what you would cite it for today. If you, again, and if you're the state and you're somehow arguing again, you would be trying to distinguish whatever case you have, from this particular one. So Maya, let's do Pierce, which is, again, still substantive due process rights. Who are the parties in?
Oregon.
Oh, can I just ask a couple of questions that I forgot to ask? Yeah, because there were a few really good quotes that I meant to, and both Steve and Kristen, I thought, brought up great arguments on both sides. But there was a quote in the opinion, in the Nebraska Supreme Court opinion, that talked about what was done in ancient Greece. And it's very short. Let me just read it. In order to submerge the individual and develop ideal citizens, because that's what Steve was talking about, right? Assimilation and bringing up the youth as, U.S. citizens. Sparta assembled the males at 7 into barracks and entrusted their subsequent education and training to official guardians. Although such measures have been deliberately approved by men of great genius, their ideas touching the relation between individual and state were wholly different from those upon whom our institutions rest, and it hardly will be affirmed that any legislature could impose such restrictions upon the people of a state without doing violence to both letter and spirit of the Constitution. So, in other words, what's the purpose of that particular analogy? 7 years old, the boys were taken. Sparta, to create, again, ideal citizens. So there's the danger, again, of the state not only, in the guise of protection, right, in the guise of assimilation, in the guise of making ideal citizens, going too far. So that's the point I try to make. All right, let's go to yes. Okay, so we have the governor of Oregon as the appellant, and these schools being the appellees. So now let me look to Emily. Why don't you start?
As the state, correct?
Yes, yeah.
Do you want me to tell you the facts of?
Yes, yeah. So how is it that you're up before the Supreme Court? What are you appealing?
So the case is based on the Compulsory Education Act, which requires every parent, guardian, or other person having control or charge or custody of a child to send him to a public school for a period of time.
Right.
And failure to do so is a misdemeanor. So the state
So what is your argument as the state? How is it that you have the right to enforce the law of compulsory education even against these private schools? Compulsory public education, that is. So you heard your co-counsel's argument in Meyer for the state, which is
Yeah.
a similar kind of argument, right?
Yes. So the two schools are bringing up their protection under the 14th Amendment because they're claiming their businesses are being destroyed.
How does the state have the right to regulate all schools, or the duty?
The state runs the schools.
One. Again, what gives the state this kind of power to regulate schools? Why do you want to enforce or be able to enforce compulsory education across the board for every child in the nation?
Make it standard.
Okay. Anybody want to add to what Emily's saying?
Basically, my co-counsel is saying it's the sovereign power of the state to do that. By standardization, we're ensuring that all children have the equal opportunity to an education on that. And therefore, the state has compelling interest in ensuring that they have a standardization. We cannot infer by any standards whether a private or a parochial school might have the same standards set forth by the state under statute.
Let me hear from the appellees here, the schools.
Schools feel that it hampers not only their ability, but also the parents' ability to choose where their children are educated and how their children are educated, and that the state is intruding upon the parents' natural abilities to raise their children.
So you represent the schools here. Are we talking about the schools, what due process rights? It's obviously not life. Is it liberty or property? Is it both?
It's In this case, it's.
I mean, the schools are running a business.
Schools are running a business, so there's kind of a property right, but there's also a liberty interest at stake here because the liberty because the parents are also entwined in this too, because they chose our schools, these two particular schools, for their children. So there's a liberty interest at stake in regards to the parents about where they send their children. So there's a rational basis to use here. Is there a compelling government interest a rational government interest related here for the state to step in and say, no, that every child has to go to a public school and just shut down all private schools, which is what the effect of this law would be.
Do you want to rest? No, wait a minute. Your side is the appellant. I'll let you have the final say. Melissa, Gabby, Carrie.
I'm a child, but I.
Oh, I'm sorry.
Am I the judge or am I?
Why aren't you a judge today?
I don't know. That's what I'm trying to figure out.
We keep changing our rules, don't worry.
I can make an argument anyway. So, wait, what side am I on?
Go, girl.
I'm on the state side, right? Well, then my argument doesn't really work. I can argue for their side. State side, let's see. I guess I would just stick with what Steve was saying, that it's gonna be
All right.
an even
So we'll let you
playing
rest.
field. Yeah.
And let's all talk about it now.
Yeah.
All right. Okay. Now you can be a justice of moves. All right.
Well, that changes everything. I was going to be his co-counsel. I had it right in front of me. I just didn't think that's what you wanted me to say.
Well, it's a daylight talk show.
Well, still, you can be a justice that has a point of view. How do you want the case decided?
Okay. All right. I got you. I got it. All right. So I'll just reword it a little bit.
Yeah.
So my question then would go to the schools. What is your opinion on the idea that these suits are premature and you're asking for, it seems like, an injunction for an injury that has yet to take place?
You are correct. We are saying that this case is right. Am I there yet? Yes. Because the injury is imminent because the state said that they will be enforcing their compulsory education act against us, and therefore we ask the court to agree with us.
Thank you.
What does anyone know about private schools? Obviously, this was private schools back then, but private schools either historically or...
No, public funding.
You're privately funded.
Yeah.
I went to private school my whole life, so I got the same, if not somewhat of a better education. Not to say, but in comparison to where I lived, than the city offered. So, going with what one of their arguments is, I haven't seen any reasoning or evidence that private education is harmful.
Okay.
But now most states require private education to be certified to the same
Yes.
levels
Yeah,
that
that was
public
the other thing I was
educators
gonna
are.
So
you have to
we're
have the same curriculum as everyone, so it is still that even playing field with just minor things here and there that you could probably do because you're privately funded.
And so the court... Go ahead.
I'm sorry, for instance, I know my kids go to private school now and they don't have to take the MCAS.
Yeah.
So it must be significantly different in the curriculum because they take the Stafford testing instead, which is nationwide. So their numbers have to stay high because the parents are looking at the children's numbers,
So you can understand why back then when the private school industry was beginning, the state is wanting, again, all of its young citizens to get the same kind of education. And that was their basic argument. Of course, the state lost. The Supreme Court held, yes, you can certainly compel children to attend some school, but it doesn't have to be a public school. And again, just like Meyer, even though the parents, the family, we're not parties to this proceeding, the Supreme Court again takes it as a family rights case. And even famous quote, and you I don't know if you saw it in this case, but other cases have cited this quote over and over again for family rights.
Is it the one, the child is not a
The mere
creature?
creature of the state, exactly. So later cases cite that famous quote, the child is not the mere creature of the state. The state can certainly regulate, but up to a point. And that point has to be, again, rational, because we're talking about substantive due process rights, but that don't quite rise to the level of, fundamental where a compelling state interest would be the test. And that's Pierce. Again, 1925, still cited for family law rights.
So the state was, looking at the time frame, the state's main concern, or at least one of them, it would appear, if I'm understanding this right, was that they don't know what's going on in the walls of a private school, so they're not 100% sure that the kids are going to come out educated appropriately, and that's why they were trying to step in.
Exactly.
Okay.
And as was pointed out, there's some regulation, but up to a point, there's differences between, private and public. And of course, we have homeschooling as well, which another sort of like an exception to compulsory education, but really not, because that's still regulated, as well.
Now that you've all met me, maybe you would have a change on views on how private school people turn out. Maybe not all that good.
That explains a lot, Karen.
Is this the first case that opens the doors that parents can
Meyer and
choose to
Pierce.
homeschool, private school?
Well, sure opens the door, but
It's
way
kind of
back
floodgate,
when.
yeah, so-
Homeschooling is, much later in the nation's
Yes, this
history,
is like the
but
floodgate maybe
exactly.
opening.
Yeah.
Oh, cool.
anytime you want to argue family rights, you're going to, and you will see judges and lawyers citing Meyer, Pierce, Prince, and Yoder, these first four cases that I've given you that are the older cases. Now, Prince has a different twist, and so let's get into Prince. Should we do it the same way? Yeah, let's do it the same way. Let's have Brooke argue for Sarah Prince, and let's have Gabriella argue for the state of Massachusetts. Brooke, you want to go first?
Oh, okay. I'm sorry, I thought the other side went first, I'm confused.
Am I co-counsel?
Everyone's co-counsel, all right?
You got it.
So basically, this is a case that comes up because my client, Sarah Prince, was convicted of violating the Massachusetts child labor laws while she was exercising her religious freedom.
What did she do?
Her niece, who was in her custody, was distributing, well, actually didn't even distribute, was attempting to distribute Jehovah's Witness pamphlets at nighttime. And none of them were distributed, nothing was sold, but she was convicted of violating the child labor laws. And basically on her part, I mean, this is religious freedom. Just because a church is one person's place to worship doesn't mean that a highway can't be another person's place to worship.
So what's the nature of your client's rights as a parent here?
Yes. Well, as a parent, to decide for their children's religious freedom. But I don't know, the state's charging them with child labor violations.
Okay, so I want you to refer to specific amendments.
Oh, okay. Let me see.
She's a parent, and so Meyer and Pierce, let's look back at the other two cases as well. Meyer and Pierce referred to parents' due process rights under the 14th Amendment. Does she have a due process right?
Yes.
And then you also mentioned she's asserting her freedom of religion under the...
I can't remember which one that is, I'm sorry.
The First Amendment.
I should have that one.
Right.
So just to be clear, the nature of her rights is different from the families in Meyer and in Pierce, correct?
Yes.
How does that change the way the court should look at the statute for which she was convicted?
Well, now I feel like they're finally integrating the child into it, because this is, before there wasn't as much mention of,
She's the party here, though. And-
but
and
it's
she's the
her
one that's
decisions that she's
asserting-
making for the child.
Okay, this court has to make a determination as to whether this statute violates your client's rights, correct?
Yes.
Okay, so what standard should this court use? I'm gonna let you think about that,
Okay.
and then I'm gonna go to the state and I want to hear their argument. Gabriella,
Okay.
you're on.
The state's argument is that the children need to be safeguarded from the parents putting them out there, on the streets, I guess.
All right, here's my question again. We appear to have a parent here who has sort of a double in the nature of rights. As a parent, she has a general due process right under the 14th Amendment to bring up her child without state interference. But she's also asserting her First Amendment religious right. And so does that not make it more difficult for the state to overcome against her argument? Shouldn't the standard that this court uses be a different standard than the standard the court used in Meyer and in Pierce? Don't you have to show a compelling state interest, not just a rational basis, but a compelling state interest in order to have Sarah Prince's conviction stand? So, and if you agree with me, what is the compelling state interest? You started to talk about the child, so you were getting there.
The compelling state interest is that street preaching is not the primary use of highways for adults, much less a child of 9 years old. And though a parent or a legal guardian, as it were, has the freedom to raise their own child under their own terms, they can't do that over the boundaries of state child labor laws. Specific reasoning would be that, to quote the case, the likelihood that some evils the legislation, it cannot forestall all of them. The zealous, though lawful exercise of the right to engage in propagandizing the community, whether in religious, political, or other matters, may at times create situations difficult enough for adults to cope with, and they're wholly inappropriate for children. And it also goes on to say that parents are free to become martyrs of themselves.
Another famous quote.
Yeah, they can't, at the same time, they can't put a child that's not old enough to use their own discretion as to whether or not this would affect them emotionally and mentally down the road. They can't make that decision for them and force them out
What
on
was the
the
little
street.
girl doing? She was only going around, it wasn't even late, it was Sunday night, they weren't looking for money. She was just dropping off pamphlets.
She was attempting to sell them.
Yeah, for 5 cents.
Yeah, and it was not the first time that, what is the mother's name? Sarah. Not the first time she had run-ins with the police for the very same thing. So although the child at this particular instance hadn't yet sold anything that night, there was record of the child selling the pamphlets prior to. She'd already been cited repeatedly for it.
Well, just because she was cited for it doesn't make it right that they were citing her. I mean, I think they were wrongfully citing her because this is part of the religion. This is what they do in their religion. They have to preach the gospel and...
But preaching and selling is two different
But however, the
things.
state's not trying to
So-
abridge the rights of the
so
parents
wait,
first or
look,
14th.
It's my decision as a
Make the
parent.
argument then that that the state has a bigger hurdle in this case than in the other cases we just looked at. So how is it, can the state overcome that hurdle? Of course, it's your argument that it can't,
They can't.
but why not?
I just don't think that you can just delve that deeply into someone's personal life and choices and decide that what they're doing for their children isn't right when no one's being harmed. You know what I mean? It's one thing for the state to step in and say these children are being harmed because they're being abused or something like that, but I just don't think that it's provable that she's certainly not working. Where's the 5 cents gonna get them another flyer? You know what I mean? It's not for profit.
The state
I
doesn't
heard
have,
from Emily.
the state doesn't have a compelling interest to regulate this parent's 14th Amendment in the right to bring a child up without their interference.
I think the state does, I think this is where we start to look at the best interest of the child. The state seems to have a compelling interest, in my opinion, of the welfare of the children. And I think that it's a slippery slope. You're saying our 5 cents is going to get them another flyer. Well, what if it was more money? Would that make a difference? You know what I mean? I think that that's the state is looking at it as, we have these child labor laws, we don't want them out, you know, it was at nighttime, or whatever time, even just standing on like the public sidewalks. One thing to preach, and they have the freedom to do that under freedom of religion, but they're selling their religious, you know, methodologies and stuff. So I think that's where the boundaries get crossed.
Yeah,
Yeah.
Carrie, there's a quote in here where it says, the state's authority over children's activities is broader than over like actions of adults.
Yep.
It's right out of the case.
And I'd like to add that the child is a person as defined in the Constitution. All
Child is a
persons
person.
born or naturalized in the United States, so the state has a duty to guard against child welfare. For the welfare of the child, regardless of what the parents want, in some cases, there's a limit.
Karen, you had your hand up before.
Yeah, I was carrying you to basically took the words out of my mouth. But I feel like the state does have a compelling interest in, like Harry said, safeguarding the child. And at 8:45, I mean, it's pretty late for a child. And not only that, it did say in the case that the aunt wasn't as close to the child when the child was selling. There was some distance away from each other, so it's.
I thought they said 20 feet, right?
Yeah, I feel like that's some distance away from my.
So I mean, the aunt was going to one house and the kid was going to another house,
Exactly,
something
and
like
then
that.
that's like, and if you're on a public street or public highway, I mean, the state has like the duty to safeguard the child, and having the aunt refuse to disclose Betty's name to Mr. Perkins, you know, I feel like that's just kind of hiding something, and the state has a compelling interest into her education and safeguarding, like Carrie said, the best interest of the child, because it is late at night and she's, you know, trying to sell all these pamphlets. Yes, I get it, to gain money, but then again, at 9 years old, should the child really be out that late?
No, but I don't think it's to profit. I think it's probably just to produce more pamphlets, you know what I mean?
According to.
But as far as I'm concerned, it's my kid, and I'm gonna do what I want.
And that's exactly what, you know,
And I don't have to tell you my
boils down
kid's
to
name.
simply what parents' arguments are, along with the First Amendment piece of it as well. Obviously, big states' rights case today came out of Massachusetts, Supreme Court, 1944. But what are some of the sort of behind the scenes or social or historical or policy reasons did you think that why did the court decide this case this way?
I was wondering, do you think the fact that the child, according to the testimony, asked to go along, you normally left at home, asked to go along with the two brothers?
What was going on?
World War II.
Labor unions.
Yeah.
Okay. Unions. Child labor versus unions. We need to have adults, and there's many adults working as possible and joining unions, exactly. Couple that with, and we're going to look at Wisconsin v. Yoder next, the difference in the way the Jehovah's get treated versus the the Amish and the who else am I thinking? Christian Scientists, for example. Read some of the opinions of not only U.S. but mass courts. You know, some of the cases that deal with the Jehovah's not allowing blood transfusions and so forth. We'll read them later in the semester and so forth. Compare the language of Prince v. Mass in the way the court talks about Sarah Prince's religion versus the language the court uses in explaining the Amish religion in Wisconsin v. Yoder, our next case. It's a lot of pieces of it, but in the end, this is the pretty much the leading case when you're talking about the state's right to intervene in family life for the welfare of a child. A child, as Brooke said, that was selling a 5-cent pamphlet.
Watchtower.
I was gonna say, there was more to it
Yeah.
though, like with the.
Exactly.
From the case itself, you know, the mother or adopted, she's her legal guardian.
Yeah, she was a guardian,
something like
yeah.
that, is teaching her at 9 that she has to go out and preach the gospel. They're going to be led by a little child. Like, for 9 years old to hear that, I'd be like, all right, well.
My parents taught me younger than that I had to go eat the body and blood of Jesus, you know?
Yeah.
It's,
Oh, you wafer?
yeah.
Yeah, exactly.
And it goes to other things too, is compulsory vaccinations too. A lot of religions.
I don't-
Exactly what I thought.
Yeah, that's a big deal.
That's exactly.
Yeah,
I mean,
that's
there's
a
a
big
great
deal.
quote in here about parents are free to become martyrs, but it
Yeah.
doesn't follow that
Yeah.
they're free to make
Right.
martyrs of
Yeah,
their
so
kids.
we had from Pierce, child is not a mere creature of the state. Now on the other side of it, parents can be martyrs themselves, but they shouldn't subject their children, blah, 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 again on the state's side. Again, and all these cases that you're reading so far, still good law in terms of family rights versus states' right. And it's funny because when you look on the face of it in terms of the test used, first two cases, rational basis is an easy test for the state, but the state doesn't win. Whereas in Prince, compelling state interest is a difficult test, yet the state wins because, again, of some of these reasons. Wisconsin v. Yoder, that we're going to get into now, I believe that I gave you in your CD both the majority opinion and the dissent as well. So I had mentioned before that sometimes I give you the dissent for a reason. So let's look at Wisconsin v. Yoder, and let's have some parents arguing about the right to practice the Amish religion. First of all, how about if someone first on the part of the parents, and I'll open it up to you guys in front of me too, could you describe either what you may already know about the Amish religion or from reading the case, what you know about the Amish religion? Anybody want to volunteer for that?
So it's a way of life for them more than just even a religion.
Can you describe that more fully?
Yeah, so like they're very, I've actually been to Amish country.
You have, okay.
Yes. You know, it's almost like they're time warped, like there's no, you know, there's still horse and buggies, no electricity, you know, definitely no social media. You know, the way they dress, the way they are still, you know, doing the way they cook, like I think a lot of them don't even have restrooms, they have the outhouses. I mean, it's, like I said, it's time warped, but it's a very simple way of life that they, you know, that's like their whole world. And they basically, they let their kids go to school, like same thing as you learned from the case, that they have let them go to public school to basically learn, like, you know, fundamental like things that they need to just exist in even their society, never mind outside of their society. But then after that, they feel that it would be, you know, contradictory to their lifestyle for them to be integrated into other school systems or, you know, anything else above the age of 8th grade or whatever, you know, it's probably like 12 or, so they obviously want them to have like some intellectual and socialization skills, but not enough for them to want to go away from the Amish community.
Okay. And so Brooke, where you just made the argument for Sarah Prince, would you be making a similar argument for the Amish parents in this case?
Oh, yeah, sure. It would just be the same thing that they have the right, you know, well, like we're going on the religious freedom thing still, you know? If you're just looking at it from that aspect. They're saying that it's detrimental for the children to go to high school because of the social norms that are accepted, that aren't accepted in the Amish community. So it basically is detrimental to their religion for them to go to high school.
Let me hear from another parental advocate as well. You guys.
Well, going on what Brooke was saying is that it's once going beyond the 8th grade, that they are fine with an education. Beyond that separates them from God because they start to get influenced away from their teachings and way of life. So they did mention
So this case was
separate.
obviously decided later in 1972. The 70s were like the sort of the explosion of due process rights, you know, not only in the adult realm, but for families as well. So what cases would you have relied on if you represent the Amish parents? I mean, you obviously would have to distinguish Prince. What distinguishes Yoder from Prince? And while you're thinking about that, what about the state's argument in Yoder, state of Wisconsin?
It's breeding ignorance.
What's that?
Breeding ignorance. Pulling a child out at 16 when they have, you know, those are still formative years mentally for the child. You want the child to be socializing with other children, learning different values, learning different religions so that they can go out and be worldly and educated and contribute
But they
to
don't want it to
society.
be.
So
They
wait,
never will, though.
How-
That's the point.
how, if at all, do Meyer and Pierce support the state's argument? And then I'll ask that question to the other side as well.
I don't think it does. Because the state's argument is that if one of these children chooses to admonish the Amish religion and leave, you know, a couple of years down the road, they said a year or two, they're not equipped to handle a life outside of that community. I don't know how, but I feel like that's the opposite of what I would use Meyer or Pierce for, which is backing up the parental rights to choose. I'm not sure how I would argue those
So
cases.
in terms of compulsory, the state's right in terms of education,
The
how would
state
you
wants an
disagree?
even playing field like in Meyer and in Pierce. Like they seem to want everyone uniformed. So they're saying in this case, I'm thinking the state is saying like, okay, so like you were saying, if after a couple of years, if you took your kid out at 8th grade and now they've been out for when they should have been maybe in the high school level and they decided to leave the Amish community, what are they gonna do, you know, what skills and education are they gonna have versus the child who is in the high school level?
More than kids in high school.
No, I'm just saying, like, that's the way that's the state's
It's
argument.
a culture shock if they chose to leave. Everything is different.
Well, you have a compulsory education statute. So how do you start with that to engage in your argument here?
Well, it mandates children between the ages of 8 and 16 to attend public schools. So, I mean, if you, like, it's mandated, so now they're going against that.
Mhm.
As far as the state's concerned, like, that's the state's argument. It's like, okay, we have this mandated act and you're violating it.
So how do you compare Pierce?
How do I compare Pierce, as far as us from the state's point of view or just in general?
Well, it's a case that has to be followed unless the Supreme Court decides to overrule it, right?
Right,
So it's going to be cited by both sides.
right.
So with the state cites it, how is the state using Pierce to support their argument?
The state, is using Pierce to support their argument. I guess not quite sure. I mean, I would say like that public education is the way to go. I know that's not very legally to me, but
I think the answer to your question is, this case relates to peers because the state and peers, and the same thing in this case, the state is intervening with the family's decision on the upbringing of their child's religious practice and relating it into, comparing it with schools. And I think that, because in peers, which was the two schools, the state intervened about religious practicing, and so the state here is also intervening within the.
But doesn't, and this question goes to the other side, doesn't the Supreme Court in Pierce acknowledge that children have to go to some school?
yeah.
Yes.
So how would you answer that? You
Well,
represent
high
the-
school isn't that after 16?
But no, you're in
Eighth grade.
You're in eighth grade is
Yeah,
like,
8th grade.
I was like
So
13, 12.
the argument would, for the Amish,
Yes.
would be that, I don't know.
They do have school, don't they? I know for the state, but didn't they mention
Yeah,
that they're not
they have
done learning, it's just
informal.
different. They're taught to like physical work.
Taught by
Vocational
the
education.
community
Yeah, but they're
itself.
still
like a
being
boat.
taught, it's just not the same way.
Yeah. It's like you said, see if you chose to go to vocational high school versus a regular high school.
Which can be done.
Yeah.
So how do we go back to the earlier question that I asked Brooke? How do we distinguish Yoda from Prince?
Well, Prince didn't have anything to do with, oh, no, I lied.
Because the nature of the parental right is exactly the same in Prince and in Yoda. In Prince, the parent loses. In Yoda, the parent wins. How do you distinguish it, Bob?
Well, one of the problems is the difference between, it's legal. In Yoda, they bring up the free exercise of religion. In Pierce.
No, Prince. Did I say Pierce? I'm sorry.
No,
I said Myron
Oh, you
Pierce
did.
before, but now I
Oh,
switched
you
to
said
Prince.
Now you're saying Prince.
Yeah.
Oh,
So the parental right is the same,
right,
In the
the Jehovah
two
Witness
cases.
case. Yes, okay. Yeah.
but
I'm sorry, I was
Sarah
thinking
Prince
Pierce.
loses, the Yoders win. So how do you distinguish the two cases?
Because
Both good law.
The dates?
So they're both in the same level.
Good guess, no.
I think that the Prince case established that your freedom of religion and the right to make these parental decisions are, they're important liberties, but they're not absolute. So,
You're going to hear that a lot about parental rights being, again, very important liberties, but not absolute. The state is able to intervene when?
for the best interest of the child.
Well,
Harmful.
Harmful.
Yeah.
So what is the difference in the children? So if you,
Right.
before I pose the question as the parental rights, but if you examine the children
That's a decent.
in the two
dissent,
cases, the argument would be made that the child's welfare is really at stake in Prince because the child is out at night, we have these labor statutes, blah, 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 blah. Whereas the court builds up the Amish community, as you all have so nicely summarized. And so it could not be said that the Amish children's welfare would be endangered.
Oh.
That's the major difference between the two cases in terms of, family versus state. Now, the dissent begins to bring up, as when Paul asked before, what about the children?
Right.
And I entitled it in your syllabus, What Voice for the Child? And the dissent talks about Vernon Yetzi and what's the other one's name?
Yeah, Douglas.
And saying that children should be entitled to be heard.
Going with what you said about just because the parents are martyrs for their religion or whatever. they
Exactly.
want, and now their kids have to be too, and that's what they said in the dissent.
So the court in the majority, as with all of these cases, never heard directly from children. The dissent raises that concern. Can we hear, and then, what are the thoughts? Number one, should we hear from these children? Does your answer change depending, say, on age and maturity in terms of hearing from children directly?
Actually, we did hear from a child in Prince versus Massachusetts. The 9-year-old said she wanted to go with the mother.
The mother said that.
That's
We
what
didn't
the mother
hear from the
testified.
child.
Oh, I'm sorry, she didn't testify. The mother
That's the
testified.
point
It's hearsay.
that Justice, who was the dissenting judge in Yoder? I forgot.
Douglas, was it?
Douglas.
Douglas.
Okay, that's the point that Douglas was making. We never heard directly from Yahtzee and Miller, who are now, I think they were about 16 at the time or something like that. Terry,
I go back to family law on this because
did you read this for family law?
I don't remember if I read this case, but I'm thinking of just hearing the child testify or not even testify, but having like a GAL and hearing what they had to say.
Yeah,
I mean,
yeah.
I know that it has some weight, and I feel like it's probably going to be circumstantial, I think, no matter, like, it's going to be it has to be case by case.
What's it, when you say it?
I'm sorry, like the child's opinion, case by case, because like I remember reading like, well, daddy buys me like all these toys and candy and everything when I'm at his house, so I want to live with him.
So the point is voice.
Right.
It doesn't necessarily mean it's going to carry the case. The point is what voice for the child. So again, the early cases where you didn't have children having a voice, in particular because children didn't have attorneys, people talked about that the family, the parents, could make the argument for the child, just like Sarah Prince made the argument for her child that, my child is also Jehovah and she wants to do this. But you're not hearing directly from an attorney that's saying she wants to do this or she doesn't. Same thing with Vernon Yahtzee and Barbara Miller. You're hearing from their parents saying they're Amish and blah, 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 and this is what we do in our community. But that doesn't mean that in the end that's the right thing and what the judge decides. It only means that the judge gets to hear from all of these voices, and that's why we have the 3 pieces of the triangle. The judge hears from the child, the parent, and the state. And the child's opinion and voice could be the most unpopular. Later on when we do that child sexual abuse study, the children were saying from the beginning they had disclosed something and then went back and said, no, we can't tell you. There's a lot to it. But the point was that they needed to be heard. As unpopular a viewpoint as a child who's allegedly sexually abused saying he or she still wants to remain at home. The judge still needs to, otherwise the judge is not getting all of the facts of the case, all of the opinions and so forth. So that's why I always throw in the Yoder dissent. It was one of the first times chronologically that courts, began to look at, maybe these kids need attorneys or people directly to speak for themselves, not just the state's attorney, not just the family's attorney. And I guess we're going to have to end here. So we'll finish up really quickly these other 2 cases because I want to get into Galt. And again, so far we've been looking at substantive procedural due process rights of the family as well as First Amendment if they're also asserting religion. Later on with Galt, we're looking at procedural due process rights of the child, and that's why that case is so important. So I'll see you all on Tuesday. Hopefully we will have